business for which it was created. All persons having business before this court draw near, give attention, and you shall be heard. God save the United States, the state of Tennessee, and this honorable court. Criminal Court Judge Sandra Donaghy, Chancellor Casey Culbreth, and Chancellor Patricia Head Moskal presiding.
Thank you and good morning. Again, welcome to Davidson County Chancery Court Part 1. We are here for today's hearing before a 3-judge panel assigned by the Tennessee Supreme Court to hear this case. I'm Chancellor Pat Moskal, serving the 20th Judicial District in Davidson County, where this lawsuit was filed. Joining me on the panel are Criminal Court Judge Sandra Donaghy, serving the 10th Judicial District in Bradley, McMinn, Monroe, and Polk counties, and representing the Eastern Division of Tennessee, and Chancellor Casey Culbreth, serving the 25th Judicial District in Fayette, Hardeman, Lauderdale, McNairy, and Tipton counties, representing the Western Division of Tennessee. Today is Tuesday, July 1st, 2025. The case called for hearing is number 23-1196, Part 1, Allyson Phillips et al. Versus the State of Tennessee et al. Before we proceed, I would like to remind all participants that today's hearing is being live streamed at the ongoing request of the public and the media. I want to thank the Tennessee Administrative Office of the Courts for making arrangements to live stream today's hearing on the 10 Courts YouTube channel, as well as setting up today's Zoom hearing. And because the hearing is being live streamed, I do want to remind all participants, including our panel judges, to be sure to speak into the microphones for the best audio quality. I would now like to ask one attorney from each side to introduce yourself and your co-counsel who are attending the hearing today by Zoom. For the plaintiffs.
Good morning, Your Honor. Linda Goldstein for the Center of Reproductive Rights, representing the plaintiffs. I'm joined today by Nicholas Cabot, also of the Center for Reproductive Rights, Jamie Levitt of the Morrison and Forster law firm, and Scott Tift of the Barrett Johnston firm. And Mr. Cabot and I will be splitting the argument, and Mr. Cabot will begin by addressing mootness, standing, and sovereign immunity, and I will discuss the sufficiency of the Second Amendment complaints clauses of action.
All right, thank you very much. Good morning to all. And representing the defendants.
Good morning, Your Honor. Jenna Adamson from the Tennessee Attorney General's Office on behalf of state defendants. I'm joined by my co-counsel, Stephen Griffin, this morning.
Good morning. Welcome to all. And I see we do have a court reporter present, and I would ask the court reporter that if you are having difficulty hearing any portion of today's Zoom hearing, to wave or it somehow indicate that we need to adjust. Today's hearing is not an evidentiary hearing. It is on oral argument on defendant's motion for judgment on the pleadings, as well as defendant's related motion to exclude plaintiff's declarations. And I know that plaintiffs have not yet had the opportunity to file a written response to the motion to exclude declarations, which the panel will allow the opportunity to do so. But I'm going to invite both sides, the defendants and the plaintiffs, to go ahead and address that motion at the beginning of your argument, briefly, if you choose to do so. We will first hear from defendants' counsel for their opening argument. Then we will hear from plaintiffs in response, and then we will hear the defendant's rebuttal argument. The panel has imposed a 90-minute time limitation for each side for today's argument. Defendants, as the movants, you may divide your time between your principal argument and your rebuttal argument. But don't feel obligated to use the full 90 minutes if it's not needed. And please also know that the panel members have read the motion, the memorandum in support, and plaintiff's response memorandum. After argument is concluded, the court will take defendant's motions under advisement to allow the three-judge panel the opportunity to confer. Counsel, are there any preliminary matters to address for the plaintiff?
No, Your Honor. I guess
All
we
right.
will at some point want to discuss a schedule for submitting a written opposition to the motion to exclude.
And we did discuss that briefly. I'm going to suggest 5 business days if you think that is adequate. I know we're coming up on a holiday, so I wanted to allow time around that. And we can discuss that at the end if that's if we need to. All right. Any preliminary matters for the state?
No, Chancellor Moskal. I'll just say that Mr. Griffin will begin with the argument on the motion to exclude the declarations, and then I will continue with the motion for judgment on the pleadings argument.
That'll be fine. All right, we're ready to proceed. General Griffin, you may proceed on the motion to exclude declarations.
Thank you, Your Honor, and may it please the court. The motion that we filed to dismiss the second amended complaint is filed pursuant to Rule 1203, the Tennessee Rules of Civil Procedure. And Your Honors, under that rule, the court only looks at the legal sufficiency of the plaintiff's complaint. Does the complaint set forth facts sufficient to state a plausible claim to relief? Matters outside the pleadings should not be considered under Rule 1203. In response to our motion for judgment on the pleadings, though, the plaintiffs attached 8 declarations, 1 from each of the patient plaintiffs and 1 from each of the physician plaintiffs, giving facts or their view on why they think the current version of the medical necessity exception is still problematic. They contain facts not anywhere in the second amended complaint that we've challenged through our motion for judgment on the pleadings. The declarations that the plaintiffs have submitted, Your Honors, are matters outside the pleadings as contemplated by Rule 1203. They are submitted for the truth of the matter asserted therein. And we think that that's improper under the rule, under this motion. Courts sometimes look at evidence outside the pleadings in considering a motion to dismiss that challenges jurisdiction. But that's only when the defendant has made a factual challenge to jurisdiction. That's not what this is. As the court noted in its order ruling on the prior motion to dismiss and temporary injunction motion, the defendants here have asserted a facial challenge to the complaint. Facial challenge is when the moving party assumes that all facts in the complaint are true, and aside from the fact that the facts are assumed to be true, the complaint still fails to assert a plausible claim for relief. That's the motion that the defendants have presented to the court here. A factual challenge.
Excuse me for interrupting for just a second, just to make the record clear. I believe in our prior order, we noted that neither side had submitted any matters outside the pleadings. And so we just made a note of that we were not considering anything outside the pleadings. I think we acknowledged both a facial and a factual challenge, but I just wanted to clarify that.
Thank you, Your Honor. The motion that we presented here is a facial challenge to jurisdiction. And that's because, as we've stated in our briefs, assuming all the facts stated in the second amended complaint are true, the plaintiffs have still failed to state a plausible claim to relief under Tennessee law. A factual challenge, on the other hand, is a situation where the complaint asserts facts that would arguably establish jurisdiction, but the defendant presents evidence that the facts related to jurisdiction are not accurate and that the evidence demonstrates the court does lack jurisdiction. A prime example is when a party files a case in federal court asserting diversity jurisdiction. The plaintiff says in their complaint, I'm a Tennessee corporation. The defendant is a Delaware corporation. Federal court has diversity jurisdiction. The defendant comes in and says, wait, no, I'm actually a Tennessee corporation. Tennessee versus Tennessee. The court lacks diversity. There is no jurisdiction. That's a factual challenge. That's not what we have here because we've asserted a facial challenge, assuming that all the facts in the complaint are true. the plaintiff still can't state a plausible claim to relief under the causes of action asserted in the second amended complaint. Nonetheless, the declarations are matters outside the pleadings. And so, Your Honor, we're asking the court to exclude those declarations from its consideration in ruling on the motion for judgment on the pleadings.
All right, thank you. Attorney Goldstein, would you like to respond at this time?
Look, yes, absolutely, Your Honor.
I know we've caught you a little bit off guard with that, in fairness, but we did want to go ahead and hear both sides' comments and positions regarding the motion, because we will be taking that under advisement.
Yes, absolutely, Your Honor. I mean, our position is that the challenge is certainly a factual challenge, although the fact is the amendment of the law. That is a fact. It's not merely a legal matter. And essentially the inference that the defendants are asking the court to draw from that fact is that the allegations in the complaint are no longer accurate in terms of the denials of life-preserving abortion care caused by the ambiguity of the medical necessity exception to Tennessee's criminal abortion ban. So the defendants are certainly not looking only at the four corners of the complaint. They're looking at the addition to the existing criminal abortion ban. And therefore, that is a factual challenge. And we are entitled to put in facts that rebut that factual challenge. And each of those declarations, as I'm sure your honors are aware, are essentially 3, or I think in one case 4 paragraphs. And all they say is that the allegations that were in the second amended complaint regarding the physician plaintiffs' fears of providing abortion care because of the ambiguity of the language in the criminal abortion ban are unchanged. They still have those fears. And the patient plaintiff's fears about being denied medically necessary abortion care in the event that they become pregnant again in Tennessee are also unchanged. They are not changed one bit by the additions to the statute that was enacted in April. So we believe that those are completely appropriate responses to the fact of the amendment and the inferences that the defendants are asking this court to draw from that amendment.
All right, thank you. All right, we will move on now to the defendant's motion for judgment on the pleadings, and we're ready to hear from defendant's counsel.
Yes, Your Honor. May it please the court, plaintiff's operative complaint contains no allegation that the governing statute has injured or will injure any plaintiff. It contains no allegation that any plaintiff was denied or feared to provide an abortion because the 2025 version of the statute is vague. It contains no allegation that the 2025 statute has, is, or will violate plaintiff's constitutional rights in any way. And the relief it requests relates to a statute that has been materially altered. This court cannot redress plaintiff's injuries by construing a statute that is no longer in force as challenged. Plaintiffs have refused to amend their complaint, which the Tennessee Supreme Court instructs is the proper course. and the fact that they felt the need to improperly attach declarations to their opposition brief proves the point. Plaintiff's main response is to argue that SB 1004 made an insignificant change, but that simply isn't plausible. SB 1004 in part mirrors the preliminary relief this court granted plaintiffs. Plaintiffs didn't ask the court to alter or amend that judgment as they could have. To the contrary, plaintiffs' counsel called that order a win and said it clarified that Tennessee doctors could provide abortion care in the listed circumstances, freeing them from fear. Plaintiffs were correct about that relief the first time. That was a real-world win for them, a win Tennessee lawmakers codified in law. Because SB 1004 made a materially significant change to the challenged statute, this court lacks jurisdiction over plaintiffs' claims and should dismiss the complaint. But even if this court had jurisdiction, defendants are entitled to judgment because the operative complaint fails to state a claim on the merits. I'll begin with our jurisdictional arguments. So to start, I think whether framed in terms of mootness or standing, the justiciability question here is whether the challenged statute causes plaintiffs an ongoing harm based on the allegations in the complaint, and whether the relief requested by the operative complaint remains appropriate. And the answer is no for a variety of reasons. In Shaw, the Tennessee Supreme Court provided clear guidance for analyzing mootness in the context of a statutory change when plaintiffs seek only prospective relief, as they've done here. And Justice O'Connor, I think, put it very clearly in City of Jacksonville, which is the opinion, the dissenting opinion that the Shaw opinion adopted. The mootness question is whether this case presents a different case after the statutory amendment. And SB 1004 makes this a different case than the one presented by the second amended complaint. And we know that both because SB 1004 made significant changes to the 2023 statute, the version plaintiffs challenged, and because a declaration of that statute's invalidity would not benefit plaintiffs because the 2025 law governs. And that reasoning is exactly why Justice O'Connor said in the vast run of cases involving a statutory change, the case should be dismissed as moot. The Tennessee Supreme Court was a little bit more generous and said that plaintiffs might receive the opportunity to amend the complaint. But plaintiffs here have waived that option. They have continually insisted that they do not intend to amend the complaint, that amending the complaint is unnecessary, and that we should proceed to discovery. Moving, Your Honor, do you have a question? No. Moving on to standing. There is no allegation that patient plaintiffs fear getting care under the 2025 version of the statute. No allegation in the operative complaint. And there's no allegation that doctors are denying abortions under that version. So the causation analysis that this court previously adopted no longer applies. And again, the declaration of the 2023 statute's invalidity would not redress plaintiffs' injuries because the 2025 statute is what governs now. Now, as my colleague, Mr. Griffin, explained, we don't think the court can consider the declarations for the reasons we explained in our reply brief and in our motion to exclude. But even if the court considered them, patient plaintiffs still couldn't show standing. And that's because there are three layers of conjecture to their injuries. First, that they would get pregnant again. Second, that they would experience a life-threatening condition that is not specifically covered by the amended statute and not similar to one of those conditions. And Your Honor, given the wording of the statute, it's hard to imagine a life-threatening condition that would not be similar to one of those conditions. And the third step is that a third-party doctor would have to make an independent choice to refuse a medically necessary abortion, even under that modified 2025 statute. And there's still, and I'll just point out, Your Honors, that when this court looked at standing before, there were at least 2 plaintiffs who alleged that they were denied abortions under the then governing version of the law. And that's no longer true, even if this court considers plaintiffs' declarations. And relatedly, patient plaintiffs also have a causation problem because injuries suffered under a prior version of the statute cannot cause future injuries. And again, only 2 plaintiffs, Plaintiff Milner and Dulong, were denied an abortion under the 2023 version of the statute. Both would be expressly covered now. Plaintiff Milner because she was diagnosed with PPROM, Plaintiff Dulong because she suffered cervical insufficiency. Moving on.
Ms. Adamson, before you move on,
Yes.
Is it the state's position that the current statute allows these exceptions to have abortion or abortion care? And I guess, let me rephrase. My understanding is that the statute may allow abortion care, not that it will. And so I'm trying to figure out what the state's position is as far as the may versus the shall.
Your Honor, plaintiffs have highlighted the use of the word may, but I think that that's a somewhat confusing position because plaintiffs have never asserted, as far as I know, that when a woman is diagnosed with one of those conditions, she must have an abortion. Instead, plaintiffs have continually insisted that not only must the doctor exercise discretion, but the doctor must have a conversation with the patient about whether to have an abortion in that case. May reflects that reading of what the statute ought to say. It says you may have an abortion or you may not. And this court is obligated to give statutory terms their plain construction and to, their ordinary meaning, and to construe them to avoid constitutional problems. And may just, it conveys by its ordinary meaning permission. You may perform an abortion. And when used in combination with may include, it indicates that the listed conditions are just exemplary of the type of conditions that would allow a doctor to provide an abortion.
Thank you.
Moving on to physician plaintiff standing. So previously,
While we're talking about the statute, forgive me for interrupting, but while we're talking about the statute, the 2025 amendment adds a definition of, quote, serious risk of substantial and irreversible impairment of a major bodily function, which was not previously defined, and it has 3 subparts to that. And that is the change. The rest of the statute remains unchanged. And this is a criminal abortion statute that is to be enforced against physicians that don't meet the conditions of this statutory provision that are alleged to have violated the criminal abortion statute. So we're picking up some interference here. Madam Court Reporter, are you
Yes,
okay?
ma'am.
All right, thank you.
So
My question is, this is just a definitional section. Explain to me why that is a materially significant change to the abortion statute.
it's significant in two ways, Your Honor. The lack of a definitional provision has always been at the core of plaintiff's challenge, and the statute now provides a definitional provision. Plaintiffs, I understand, argue that that's circular because it uses part of the term that it's defining. But it adds clarity in a number of ways. It clarifies what a serious risk looks like. And when the court is considering how it has clarified that, it needs to read that first definitional provision, subsection A, in context with subsection B, which also helps clarify what level of risk will justify an abortion.
But it still doesn't define serious risk. It doesn't define substantial and irreversible impairment of a major bodily function. So those are still undefined.
Your Honor,
terms.
it's still it defines serious risk. That term is not repeated in subsection A. It means any medically diagnosed condition that so complicates the pregnancy of a woman as to directly or indirectly cause. So directly or indirectly is clarifying at least the timing concern that plaintiffs have previously expressed and continue to advance. And it clarifies that you may have a complication that might indirectly cause a serious condition, and that even in that case, the doctor would be able to perform an abortion. And again, Your Honor, I would emphasize that the inclusion of this list of exemplary terms mirrors the court's temporary injunction order. And I know
I'm glad that you mentioned that, because just again, to reset the record and the way that this developed at the temporary injunction hearing, and I recognize that you were not present and didn't present argument at that hearing, but the terms of this court's order on the temporary injunction, to the extent that's being relied on as support, I just want to clarify that that order was based upon the parties' agreement during the temporary injunction hearing that certain conditions that had been addressed by both sides, medical professionals, the experts in the case, that the state came into the hearing and said, we agree that at least these conditions would come within the medical necessity exception for purposes of the temporary injunction hearing only. That qualifier was placed on it by the state's attorney at that hearing. So I just wanted to go ahead and clarify where we were at the temporary injunction stage and the limited extent of this court's temporary injunction ruling. It was not a ruling on the merits. It was for purposes of the temporary injunction only.
Your Honor, and you made that clear in your opinion. Respectfully, I think that cuts in favor of the state, that the state only made that concession for the purposes of the temporary injunction order. That suggests that there has been a significant change to the statute since the General Assembly has now codified that position that the state only adopted for the purposes of the temporary injunction order. And also, Your Honor, I would point out that plaintiffs didn't think that that was insignificant relief. They said that was a win. They said it clarified the meaning of the medical necessity exception. They said that it relieved doctors from fear, in that it clarified when they could provide an abortion. It clarified that they could provide an abortion in those circumstances. And the statutory provision goes beyond that, because it not only includes the specific conditions listed in the court's temporary injunction order, but it makes clear by the use of the language may include that similar conditions are also covered. And so that's broader relief than the court provided at the temporary injunction stage. And Your Honor, I would also say that the court did say that plaintiff stated a claim in ruling on the motion to dismiss. And so plaintiffs could have moved for broader relief if they thought that the relief the court granted did not adequately address the constitutional violations that the court held plaintiffs had stated at the motion to dismiss stage.
It could have moved for relief. What are you suggesting?
They could have
I'm not
moved,
following your argument there.
they could have moved to alter or amend the judgment. They could have argued that
But they weren't required to.
no, they weren't, but it tells us
So they're not precluded from arguing that now.
no, not at all, Your Honor. We just think that's evidence that plaintiffs understood the relief granted at the temporary injunction stage to be significant.
Okay, please proceed.
Okay. So moving on to physicians.
And
Yes, Your Honor.
I'm interrupting again, so forgive me. I did not ask you at the beginning if you wanted to reserve any time for rebuttal.
I would like to reserve the remainder of my time, whatever that ends up being, Your Honor, if I may.
That you do not use?
Yes,
Okay, all right.
thank you. Okay, so moving on to physicians standing. Now, one key difference between our standing argument at the motion to dismiss stage and our argument now is that, as the court found in its motion to dismiss order, we didn't dispute the first injury prong then. But now we do, because the complaint has no allegation that physician plaintiffs fear performing abortions under the 2025 version of the statute that they were able to perform before. And of course, we think also on the second prong, there are no allegations about enforcement of the 2025 version of the statute. And even considering the declarations, which again, we don't think that the court may consider, physicians can't show a certainly impending threat of prosecution as they must. And that's from Tennessee, the Tennessee Court of Appeals decision and Slattery. 8 months after the court's previous order and more than 2 years after the medical necessity exception, the original one, was adopted, plaintiffs identify no prosecution or disciplinary actions. All they can show is subjective chill, which isn't enough to show an injury in fact. And I would point the court to Friends of George for its analysis of
So disciplinary enforcement, this court's temporary injunction order enjoined disciplinary enforcement. So to the extent you rely on that, I would assume that the boards are acting in compliance with the court's temporary injunction order.
That's fair, Your Honor. And then as to both, again, I would just reiterate that plaintiffs can't show that a construction of the 2023 statute will help them, given that the 2025 statute governs now. So they can't show redressability, which is both key to the standing analysis and shows that they have a serious mootness problem. Moving on to our other standing arguments. These all come down to intervening Tennessee Supreme Court precedent in Case versus Wilmington Trust. And in that case, the court held, it construed the open courts clause for the first time that I'm aware of, and held that the clause only provides entry to Tennessee courts for a plaintiff with an injury done him. And that's quoting in part Tennessee Constitution, Article 1, Section 17, the open courts clause. And that means that has two implications for this case. The first, which I think is most straightforward, is that it means a party cannot use the injury of a third party to get into court, because by definition, that means that the party does not have an injury done him. There's only an injury done to some third party. And that precludes both AMA's associational standing and the physician's standing based on their patient's injuries. And then the other implication of Wilmington Trust for this case is that it precludes pre-enforcement standing before a plaintiff has suffered an injury to himself. And I think it's important that that just restores standing in Tennessee to the understanding that the Colonial Pipeline case recognized the common law did not allow a suit in either law or equity absent an actual and present injury. And so Wilmington Trust just restores us to that understanding of standing. Moving on to sovereign immunity, plaintiffs forfeited any reliance on Section 13121 by failing to plead their claims under that section. And this is clear both from the text of the statute, which states that a cause of action shall exist or shall not exist, and from Roush, which involved a claim expressly pleaded under Section 13121, and only in that context did the court hold that sovereign immunity was waived. And Your Honor, that's clear both from the background section of Roush, and if you go back and look at the complaint in Roush, the very first claim is pleaded under Section 13121. Everyone agrees that standing and sovereign immunity overlap considerably. So to the extent that the court agrees with us that plaintiffs lack standing without the declarations, with the declarations, that means that it also affects the waiver of sovereign immunity, even if they can get past their forfeiture problem. And Section 13121 is not met here because plaintiffs are not affected persons. There's no allegation plaintiffs continue to fear the inability to provide or obtain an abortion. No allegation that physicians continue to fear enforcement for providing abortions they used to provide. And that was the basis of this court's reasoning before in finding that that aspect of Section 13121 was satisfied. And there's also no governmental action, even under this court's prior reasoning, which respectfully the state disagrees with, because there is no reference to the 2025 statute in the operative complaint. And even if the court considers the declarations, as the state explained in its reply brief, we urge the court to reconsider its ruling because of the implication that courts would be open to any plaintiff who could show that they were even indirectly affected by a statute regulating a third party. We also argue that the Colonial Pipeline exception is not met here because General Skermeti doesn't have any relevant enforcement authority, and there's no realistic possibility of enforcement by the Attorney General or boards. And I'll just point to the arguments in our brief on that. Plaintiff's own case, Russell, says that the federal doctrine that is the twin of Colonial Pipeline does not apply when a defendant state official has neither enforced nor threatened to enforce the allegedly unconstitutional state statute. And for the reasons we explained in our brief, that's what we have here. We'll now move on to the claims on the merits. And Your Honor, I think it's important to recognize that even if the court considers the declarations with respect to plaintiff's justiciability arguments, which again, we don't think would be proper, plaintiffs don't even argue that the court can consider them in ruling on the merits. And that's fatal for them on the merits because they have no allegation that the current medical necessity exception deprives any person of their right to life. We think that the medical necessity exception has always protected a mother's right to life by its plain text because it allows abortions to prevent the death of the pregnant woman. And the changes make that even clearer because they provide a list of conditions in which a woman's health is seriously at risk and says that an abortion is appropriate in those cases. So the statute, especially as amended, goes beyond protecting the woman's right to life to protecting her quite clearly against serious health risks. And this court previously held that plaintiffs stated a claim, stated a right to life claim because the abortion statute failed to apply to patient plaintiff situations in practice. But again, when the court made that ruling, there were at least 2 plaintiffs who had been denied an abortion under the then governing version of the statute. And the operative complaint contains no allegation that an abortion was denied or delayed under the current version of the statute, which is fatal for their claim on the merits. We also argue that plaintiffs fail to state either a facial or as applied vagueness claim. We think the court was correct to hold that they had not stated a facial claim before. And the clearest way to see that they haven't stated an as applied claim now is that the statute now expressly allows an abortion in each of the patient plaintiff situations where the court previously found vagueness. So those are plaintiff Dulong's, Milner's, and Fulton's situations. And plaintiff Dulong alleged a cervical insufficiency diagnosis that would be covered by SB 1004. Plaintiff Milner alleged a PPROM diagnosis that would also be covered now. And plaintiff Fulton alleged a fetal high drops diagnosis with a high risk for Muir syndrome. And that would also be covered under the express terms of the 2025 version of the statute.
Ms. Adamson,
Yes.
is it the state's position that the amendment would absolutely allow abortions under those circumstances?
Your Honor, again, this is a judgment call for the physician that's built into the statute. The physician may exercise his or her reasonable medical judgment. The statute makes clear that if the physician determines in his reasonable medical judgment that an abortion is appropriate, the statute allows it in those cases.
Okay, can you tell me the difference then between reasonable medical care and the commonly accepted good faith judgment standard?
Your Honor, I am not clear on the distinction that plaintiffs are drawing between the good faith medical judgment they are advancing and the reasonable medical judgment standard. But I would point the court to the Tennessee Court of Appeals decision rejecting the sort of best medical judgment standard for which plaintiffs advocate as overly subjective and as likely to create confusion with the jury because it rests on the credibility of the doctor. So I would direct the court for any distinction, if there is one, to that decision. And that decision upheld the the ordinary and reasonable judgment standard that applies in ordinary medical malpractice cases under Tennessee law.
Thank you.
Again, on vagueness, this is physician plaintiff's claim, but there is no allegation that physician plaintiffs are no longer providing medically necessary care under the 2025 version of the statute due to vagueness concerns. And again, the court cannot consider the declarations in deciding whether plaintiffs have stated a vagueness claim. We also don't think that it is a reasonable inference that physician plaintiffs are no longer providing medically necessary care under the 2025 medical necessity exception because the new exception adopts this court's temporary injunction order. And again, plaintiffs clearly considered that to be meaningful relief. And lastly, I'll just touch briefly on the equal protection claims. So first of all, the equal protection claim related to mental health fails because no plaintiff has standing to assert it. There's no allegation that any of the patient plaintiffs suffer from a mental health condition, no allegation that the physician plaintiffs would like to provide mental health based abortions and cannot do so. So they don't have standing to assert that claim. But beyond that, both claims fail at the threshold because the classes involved for each case are not similarly situated. And I'll rest on our briefs for that point unless the court has any questions. And then lastly, plentiful rational bases support both classifications. As to the pregnancy claim, the General Assembly has previously listed all of its justifications for the abortion prohibition and the medical necessity exception. And these include the interest in protecting fetal life and regulating the integrity and ethics of the medical profession. And then as to the mental health claim, clearly reasonable, even if plaintiffs or the court think that there should be a mental health exception because mental health conditions are not objectively verifiable in the same way that physical conditions are. And we also know that there is disagreement about whether abortion is an effective or even ethical treatment for a mental health condition. And established law says that the General Assembly may adopt one side or the other, may reasonably adopt one side or the other of a medical debate like that. So in summary, we believe that plaintiffs fail to state any of their claims on the merits, but we first think that the court needs to address the jurisdictional issues as a threshold question and whether for mootness, lack of standing, or the absence of a waiver of sovereign immunity, we believe this court does not have jurisdiction. And unless this court has any further questions, I will end my opening argument there.
I do not have any further questions. Judge Donaghy
I have no questions.
and Chancellor Colbreth.
Nothing further from me.
All right, thank you.
Thank you.
That will conclude your argument. I show that you have that you used approximately 30 minutes because you started at about 9:20, and so you still have 60 minutes for rebuttal, which is a very long rebuttal. So we'll see how that goes. All right. Hearing nothing further from the defendants and no questions, we'll move to the plaintiff's counsel for your responsive argument.
Good morning, Your Honors, and may it please the court. Over a year ago, the parties stood before Your Honors to argue defendants' first motion to dismiss. Defendants argued then the same things they argued today, that they enjoyed immunity from suit, that there was no plaintiff withstanding, and that plaintiffs could not state a claim because, in the defendant's words, the exception was sufficiently clear. The court disagreed with defendants then, and now is no different. Today, 7 months after discovery started in this case, we are once again before your honors on a motion to dismiss plaintiff's case. And once again, defendants contend that they are immune from suit, that there is no standing, and that the statute is sufficiently clear. Those arguments lacked merit before, and they have no merit today. Defendants base their second bite at the apple principally on the enactment of SB 1004, a cosmetic amendment to the criminal abortion statute. In defendants' view, and I'm quoting, the amendment is a dramatic change in the law. I heard my colleague on the other side describe it today as a material alteration in the law and making this case a different case. But that grossly overstates the amendment's effect. The reality is the amendment does not change anything. For starters, as I heard your honors point out, there is no merit to the idea that there's a new law or a new 2025 exception. Tennessee Code Section 39-15-213 remains the operative law, and SB 1004 does not even purport to modify any of the existing language in the criminal abortion law. Subsection C, the medical necessity exception at the core of plaintiff's allegations in this case, was not changed in any respect. It remains word for word the same as it was before. The entire basis for defendants' renewed motion is a single definition that SB 1004 added to the criminal abortion ban, and that's it. The added definition is no more than a cosmetic change. It does nothing to clarify the many linguistic ambiguities in the medical necessity exception. For example, SB 1004 defines a substantial and irreversible impairment of a major bodily function as a substantial and irreversible impairment of a major bodily function. It doesn't even try to define any of the ambiguous subparts in that clause. It doesn't define or quantify the term serious risk. I heard my colleague on the other side suggest that that term is defined, and they pointed to the beginning of the clause in the new definition. It doesn't say that that's the definition of serious risk, and I wouldn't understand that as a definition for risk, but more importantly, it just simply raises more questions. The terms medically diagnosed condition, that's not defined. And to say that something indirectly or directly complicates a pregnancy is also completely unclear because it's preceding the still undefined term substantial and irreversible impairment of a major bodily function. And finally, defendants point to the 5 conditions taken from this court's temporary injunction order, and they assert that those conditions are allowed. But the statute only says that those conditions may, quote, may meet the exception. And it utterly fails to explain when those conditions do meet the exception or don't meet the exception. And I heard defendants' counsel argue that the statute absolutely allows abortions, or well, I did not hear the defendants' counsel argue that that abortion would be absolutely allowed for any patient that has one of those conditions. What I heard was that it would need to be subject to the physician's reasonable medical judgment, and I did not hear an explanation of whether there would be a prosecution if the physician performed an abortion, for example, for PPROM, when there was no substantial risk of a irreversible impairment of a major bodily function. And this really leaves us in no different place than before the amendment. Those 5 conditions may have met the exception pre-amendment, and they still may meet the exception post-amendment. So in sum, because nothing has actually changed with the enactment of SB 1004, all defendants are seeking here is a do-over of their previous motion to dismiss, which they elected not to appeal. The court should deny that request. And I'll turn now to mootness and then address sovereign immunity and standing. Starting with mootness, defendants claim that SB 1004 moots plaintiffs' vagueness and right to life claims. The argument fails in 2 independent ways. As a facial matter, SB 1004's text does not address plaintiffs' allegations about the ambiguity of the criminal abortion ban. And as a factual matter, plaintiffs' declarations confirm that SB 1004 has not resolved their fears, And if you draw all reasonable inferences from plaintiffs' well-pleaded allegations, you would also see that their fears have still not been fixed by SB 1004. To level set before I get into why, plaintiff's second amended complaint challenges 4 principal areas of ambiguity in the medical necessity exception. That's a use of non-medical language, ambiguous terminology, that there's no indication of timing when an abortion can be performed, and the reasonable medical judgment standard. Each of these 4 areas of linguistic ambiguity remain after the enactment of SB 1004. To illustrate why, I'd like to walk through each of the main components of SB 1004's definition. The first is that it purports to provide a definition for one phrase in the medical necessity exception. That's serious risk of substantial and irreversible impairment of a major bodily function. But it does so in a highly problematic way. First, it is an entirely circular definition. As noted already, it repeats the phrase substantial and irreversible impairment of a major bodily function. It fails to define that term or any of its subparts. It nowhere defines or explains when a risk becomes a serious risk, when an impairment becomes substantial or irreversible, and what bodily functions are major. It still uses non-medical language, even though the statute subjects physicians to criminal penalties. And it restricts the defined term to medically diagnosed conditions without explaining what that new term means. Because of these issues, the definition fails to address the linguistic ambiguities that plaintiffs allege in their complaint. And those allegations appear at paragraphs 237 to 241 of plaintiff's second amended complaint. Defendants point to the use of the phrase directly or indirectly. But again, that still precedes the still undefined term substantial and irreversible impairment of a major bodily function, which is not defined. And their allegation that that has somehow mitigated any fears is contrary to the facts in this case, whether or not you are accepting the declarations, which maintain that there is an ongoing chill, or if you're drawing all reasonable inferences from plaintiff's allegations, which contend that the medical necessity exception, which is word for word the same, has caused them to stop performing abortion care for severe obstetrical complications, and for patient plaintiffs led to them being denied medically necessary abortion care. Now, the second component that defendants lay most of their weight of most of their argument on is that the 5 dangerous pregnancy complications mentioned in this court's temporary injunction order are listed in SB 1004. But again, the key language in that part of the statute is may. Having one of these conditions is not enough on its own under SB 1004 for a patient to meet the exception. And it's not just plaintiffs reading it this way. That's what the sponsor of the legislation in the House said explicitly. He explained, it's a 2-step process. Step 1 is to have the diagnosis. Step 2 is that the physician has to, quote, determine whether the severity and circumstances impose a substantial risk. Representative Terry said the amendment helps clarify step 1 of the diagnosis. And this is on a video on the General Assembly's website. It's quite clear, and the link is in our brief. SB 1004 thus keeps the burden on physicians to determine when patients with those conditions are sick enough to lawfully receive an abortion. Defendants explain that the contingent language should be read in a permissive sense, but that makes no sense. First, to put this in context, those conditions are listed as describing just a definition of serious risk of substantial impairment of a major bodily function, which is just one term in the medical necessity exception. If you put it in, if you substitute one of these definitions into the medical necessity exception, it makes no sense. It would mean that, and I'm paraphrasing in part, an abortion is permitted only when a physician determines that the abortion was necessary to prevent, quote, previable, preterm, premature rupture of membranes. but you can't prevent what you already have. What the medical necessity exception is saying is that serious risk of substantial and irreversible impairment is something that's supposed to be prevented, much like death, which is the other prevented condition in the statute. And so it doesn't make sense to read the statute, read SB 1004 as creating a condition that assures that physicians can perform abortions. It would also be contrary to the explanation of the bill's sponsor in the House of Representatives, Brian Terry. If these conditions are examples, as defendants contend, SB 1004 gives no guidance to physicians to determine with certainty what other conditions might resemble those conditions. For example, with PPROM, why is PPROM listed in SB 1004? Is it the risk of death if it's left untreated? Is it the risk of sepsis? Is it the threat to fertility? SB 1004 doesn't say, and so it fails to give any guidance to physicians to determine what other medical conditions might fall within the exception. And finally, if these conditions only, quote, may meet the exception, that just begs the question, under what circumstances does a condition such as pre-viable PPROM not permit a physician to perform an abortion? Now, turning to the factual question, and mootness is an intensely factual inquiry, defendants' mootness arguments fail as a factual matter. Plaintiffs have submitted declarations confirming that SB 1004 does not resolve those fears. I understand this court will consider whether to consider those declarations, but if they do, those declarations are dispositive because defendants submit no facts in response. And both physician plaintiffs attest in their declarations that things are no clearer under SB 1004 than they were beforehand. And the declarations of the patient plaintiffs all attest to their continued fear of being pregnant and denied abortion care for a severe obstetrical complication in Tennessee. There are a few additional arguments that defendants made in their reply brief that I'd like to briefly respond to. First, defendants incorrectly say that we have not challenged the ambiguity of the exception's language about performing an abortion in the manner that provides the best opportunity for the fetus to survive. But we have. That's in paragraph 240 of the second amended complaint. Second, defendants repeatedly say, and they urge the same argument today, that plaintiffs simply amended their complaint. But for context, we were nearly 5 months into discovery and actively exchanging documents and discovery responses when this amendment was enacted. And because of its insignificant changes, plaintiffs believed that since they did not plan to add any additional causes of action to the complaint, it was best to address the amendment through the ordinary course of litigation. And it was not necessary as a substantive matter. If you think about it, what would have changed in plaintiff's allegations? Each of the patient plaintiff's allegations would be unchanged. Each of the physician plaintiff's allegations would be unchanged. It's the same statute and same words in the medical necessity exception as before. It has the same ambiguities as alleged at paragraphs 237 to 241 of the second amended complaint. The defendants are identical. And we didn't need to amend for standing purposes because that was already established and can't be changed after the fact. One other point before I move on is that it's easy to imagine conditions, even if you accept that the list of conditions in SB 1004 are conditions that are allowed, that allow physicians to perform abortions for. It's easy to imagine a condition that's not covered, something like cancer. And it's hard to understand how a physician is going to use SB 1004 to answer the question of whether cancer is a condition that a physician may perform an abortion for. Does it pose a serious risk of substantial and irreversible impairment of a major bodily function? SB 1004 does not answer that question. Putting all of the weight on directly or indirectly also doesn't answer that question. And looking at the 5 pregnancy complications listed in the statute also yields no useful answers. Other conditions you might think about placental abruption, sickle cell disease, anencephaly, extreme hyperemesis gravidarum. None of those conditions are conditions that doctors have any clarity on from SB 1004. Moving on to sovereign immunity. This court already decided that defendants
Can
do
I
not-
interrupt and ask a question, please? Could
Yes.
you address the analysis on the amendment of the criminal abortion statute under the Shaw case, the Tennessee Supreme Court case in Shaw?
Sure, Your Honor. So Shaw sets out that there is really there's amendments that can be insignificant, and if an amendment is insignificant, then it simply can't moot the case. There's then amendments that are completely either rewriting the law or removing a law, and those types of amendments also clearly moot a case. And then it talks about the gray area of very fact-intensive cases where the question is, has an amendment substantially altered a case or resolved the really core of a plaintiff's allegations? If you look at the analysis, we would contend strongly that SB 1004 is simply insignificant. And on its face, you can therefore determine that it does not moot this case. But if you decide that it falls into the gray area, as Shaw describes it, the question is a fact-intensive one, and plaintiff's declarations are dispositive as a factual matter. They show that SB 1004 has not resolved plaintiff's fears, and defendants have submitted zero evidence to the contrary. And thus, as a factual matter, the current record shows that SB 1004 does not moot this case. If Your Honors have...
In Shaw, the change to this it was an ordinance, a metropolitan ordinance, I believe, that was actually repealed in its entirety and replaced. That's not what we have in this instance. And also in Shaw, that repeal and replacement occurred while the case was pending on appeal. Here, we're in a different procedural posture. Does that influence the analysis in any way?
You're absolutely right, Your Honor.
Well, I'm not suggesting the answer one way or the other. I'm asking the question.
I just meant that you were right in describing the context for Shaw. And so if you look at Shaw, this is not the type of case where I think it falls into the gray area. It is insignificant because the medical necessity exception, which is really the heart of the party's dispute here, that remains completely unchanged. And so had defendants enacted a law that had substantively changed the medical necessity exception, we might be having a very different conversation. But that's not what they chose to do. They chose to add a definition. And that definition does not really define much or help any of the plaintiffs resolve their fears. So as a factual matter, I think it's more in line with something that is insignificant. And then the second issue is that we are in the middle of discovery. And so if you have a slightly altered statute, even if you don't want to rule that is completely insignificant, you might find that it falls into the gray area, but that it can be resolved on the parties through discovery to determine and argued at summary judgment whether or not on the record as it is, the amendment SB 1004 moots plaintiff's claims. At present, the record is plaintiff's second amended complaint and the declarations. But what Shaw does is it says you have raised important factual issues, and it remands the case for development of the factual record in the district court. But here we are in the district court, and we have the option to continue to develop the record on this issue. And defendants, can raise the same mootness arguments in a summary judgment posture with a more fully fleshed out record.
Thank you.
If your honors have no further questions on mootness, I'll turn to sovereign immunity.
All right.
This court previously decided that defendants do not enjoy sovereign immunity under either Section 13121 or Colonial Pipeline. Defendants renew their sovereign immunity arguments, but SB 1004 doesn't require a different ruling because it doesn't impact defendants' enforcement authority or plaintiffs' fears and uncertainties under the medical necessity exception. I'll walk through each basis of immunity waiver to show why SB 1004 doesn't change the outcome. Starting with Section 13121. This court correctly ruled in deciding defendants' first Rule 12 motion that Section 13121 waives sovereign immunity because it involves constitutional claims seeking declaratory and injunctive relief brought by plaintiffs against the state of Tennessee and the boards. The court's ruling was squarely in line with what the Tennessee Supreme Court held in the Roush case. Defendants make the same arguments as they made in their previous motion to dismiss. As to governmental action, this court held that there is sufficient governmental action in two ways. First is that both physician plaintiffs stopped providing medically necessary abortion care after the criminal abortion ban took effect out of fear of its threatened enforcement against them and fear of being subject to 15 years of imprisonment. This chilling effect leads to the denial of abortion care to patients like the patient plaintiffs in violation of their rights. The analysis isn't any different now. Both physician plaintiffs make the same supporting allegations in the second amended complaint at paragraphs 160 to 180, and their declarations confirm that the criminal abortion ban continues to chill the performance of abortions for patients with severe obstetrical complications. Second, this court held that the enactment of the abortion ban supplies the requisite governmental action because none of these claims would be asserted but for the law's enactment. And again, the analysis is no different. The enactment of SB 1004 can't undo that earlier governmental action. It's simply another governmental action subject to challenge. On the other prong of the Section 13121 analysis is affected persons. And again, this court already held that plaintiffs' allegations were sufficient to show some real interest in dispute. And that remains true. The physician plaintiffs, as to the physician plaintiffs, this court held that each was an affected person because they, one, alleged they no longer provide abortion care that they regularly provided to their patients before the enactment of the ban, and I'm quoting, and two, it is unclear whether the abortion care they believe is medically necessary will nevertheless subject them to criminal prosecution and penalties. And I just don't see how defendants can argue that SB 1004 impacts this analysis. Plaintiffs make the same allegations in the plaintiff's second amended complaint. Again, that's paragraphs 168 to 180. And the declarations attest that the allegations are true after SB 1004. As to the patient plaintiffs, this court held that each was an affected person because they fear becoming pregnant again in Tennessee after having been denied emergency abortion care, or were fearful of their inability to get medically necessary care in Tennessee if needed. Again, SB 1004 does not impact this analysis. The allegations in the second amended complaint are the same, and the declarations confirm that SB 1004 has not diminished patient plaintiffs' fears. Now, defendants raise only one new argument that doesn't arise from the amendment, and that's that plaintiffs have somehow forfeited reliance on Section 13121. But that's just completely baseless. As an initial matter, the second amended complaint is expressly alleging that, quote, sovereign immunity has been waived pursuant to TCA Section 13121. That's at paragraph 45. Second, there's no basis for defendants' supposed requirement that claims need to be stylized as arising under Section 13121. Roush explained that 13121 expressly recognizes the existence of, not creates, causes of action regarding the legality or constitutionality of a governmental action that seek declaratory or injunctive relief. Roush consistently refers to section 13121 as a waiver of sovereign immunity, not as creating a cause of action. What section 13121 excludes from recognition are claims seeking monetary relief, and plaintiffs don't seek monetary relief. And as a third point, we don't need a new cause of action to bring our claims. There's no question that Tennessee courts can hear constitutional claims that seek declaratory and injunctive relief. Colonial Pipeline involved just such claims. If your honors have no questions on section 13121, I will turn to Colonial Pipeline.
Please proceed.
Pivoting to the individual defendants, this court previously concluded that they do not enjoy sovereign immunity under Colonial Pipeline. Colonial Pipeline squarely held that sovereign immunity does not bar a declaratory judgment or injunctive relief against state officers to prevent the enforcement of an unconstitutional statute, so long as the plaintiff does not seek monetary damages, which we're not doing here. Colonial Pipeline looks at the enforcement authority of the individual defendants, and there's no requirement that the state officials have acted outside their authority in the past, and the defendants don't cite any case that that's a requirement. The court already went through the enforcement authority of each defendant in its previous opinion, and so I won't restate the analysis in full here. But the court determined that they each had authority to enforce the abortion ban against the physician plaintiffs. SB 1004 does not alter defendants' enforcement authorities, so it doesn't provide a basis to change this court's prior decision. So that's sovereign immunity. Turning to standing, this court correctly determined in ruling on defendants' motion to dismiss that both physician plaintiffs and patient plaintiffs have standing to bring their constitutional claims under the familiar three-element test. The same reasoning supports the standing of Plaintiff American Medical Association, which has associational standing through its physician members, including both physician plaintiffs. Based on this court's ruling, there should be no debate that both sets of plaintiffs had standing when the second amended complaint was filed. Standing is judged as of the date of the filing of the complaint. City of La Follette, cited in this court's previous decision, makes this point clearly. And the case law is also clear that subsequent events do not deprive a plaintiff of standing. They go to mootness, which is a distinct analysis, best illustrated by the Shaw case. If the court requires a recent decision making that point, Patton versus Fitzhugh, which is a Sixth Circuit decision, 131 F4 383, makes this point very clearly. Defendants are flat wrong that SB 1004 entitles them to a do-over on standing, so it's unnecessary for the court to revisit its previous standing analysis. The medical necessity exception that injures plaintiffs remains unchanged. Again, it is word for word the same. But even if your honors were to assume that a post-filing amendment could affect plaintiff standing, SB 1004 doesn't, as a factual matter, impact any plaintiff standing because it does not resolve their fears, as demonstrated by the declarations. With that, I'll turn to address AMA's standing. The AMA is the largest national association of physicians, and it joined this case in March when plaintiffs filed their second amended complaint. The AMA meets all three elements of associational standing: individual member standing, relevance to purpose and policies, and the necessity of individual member participation. Defendants only contest that AMA satisfies the first element, but that's baseless. Both physician plaintiffs are AMA members, and this court already found that they have standing. And SB 1004 does not provide any basis to weaken physician plaintiff standing. That is sufficient for the first associational standing element. Next, defendants do not appear to contest that this lawsuit is germane to AMA's purpose and policies, and that no additional AMA members are necessary parties to this case, the second and third elements of standing. For the avoidance of doubt, AMA satisfies both elements, and I'll rest on our arguments and our papers on those two elements. turning to Wilmington Trust, defendants are unable to challenge AMA's associational standing. And so instead, they claim that Tennessee law does not recognize associational standing, but that is wrong. Defendants concede that intermediate appellate courts have recognized associational standing. Those decisions are binding on this court. Undeterred, defendants asked this court to rule for the first time that Tennessee does not recognize associational standing. They also rely on Wilmington Trust to argue that there is no third-party standing, that there is no pre-enforcement standing. And so you would think that Wilmington Trust addressed those issues, but it didn't. Wilmington Trust does not address associational standing. It doesn't involve an association. Wilmington Trust doesn't address third-party standing. No one who's claiming third-party standing. And Wilmington Trust doesn't address pre-enforcement challenges because it's not a pre-enforcement challenge. Wilmington Trust addressed the standing requirements for a private law action, such as torts or breaches of contract. The facts of that case involve a wrongful foreclosure claim. And finally, defendants have rested their arguments on the Open Courts Clause and the provision that an injury must be done to him. But here, each plaintiff has an injury to him, or to her in this case. The physicians have established injuries, as this court already previously found in its prior opinion, and each patient plaintiff has an injury, and the AMA members have injuries, which is sufficient for AMA's standing. With that, unless the court has questions on mootness, sovereign immunity, or standing, I will rest there.
All right, thank you very much. Let me turn to Judge Donaghy. Do you have any questions on those issues for Attorney Cabot?
I do not. Thank you.
All right, Chancellor Colbreth,
None for me.
any questions? All right, thank you very much. We're ready to move to the failure to state a claim argument. Attorney Goldstein, according to my clock, I think you have, I believe Mr. Cabot used 35 minutes. And so you have the remainder of the
Your Honor,
time.
I wanted to address one small point that they had made in their defendants made in their argument. They argued that none of the physician plaintiffs had standing for the mental health claim. And that's just flat wrong. I mean, for starters, both physician plaintiffs mentioned wanting to treat patients with psychiatric conditions, quote, including those that may lead to suicide in the second amended complaint. That appears at paragraphs 170 and paragraphs 176. Defendant's argument simply ignores the actual allegations of the second amended complaint as to this point. And those physicians have standing to seek relief for those claims because it comes within the standard of care. And to the extent that defendants are suggesting that a physician needs to have treated every single condition already, that's simply wrong. The relief plaintiffs are seeking would encompass mental health conditions because it encompasses all conditions where it is posing where pregnancy is high risk or complicated and abortion is within the standard of care for it. So I will rest there and yield the rest of my time to my co-counsel, Ms. Goldstein.
Right, thank you very much.
Nice.
Ms. Goldstein.
Thank you, Your Honor. I hope to use only a fraction of that time.
Okay.
Mr. Cabot has thoroughly addressed why SB 1004 does not moot any of plaintiffs' constitutional claims. Those arguments also apply to why the causes of action that this court has previously upheld continue to state a claim. In its decision largely denying defendants' first Rule 12 motion, this court held that each of the 6 patient plaintiffs adequately alleged a violation of her right to life under Article 1, Section 8 of the Tennessee Constitution, because each plaintiff patient alleges that her medical situation should have been covered under the medical necessity exception, but the statute's vagueness, coupled with her doctor's fear of prosecution, prevented them from receiving medically necessary abortion care. That's at page 21 of this court's opinion. The second amended complaint makes identical allegations about the denials of patient care. Given the entirely cosmetic additions to the medical necessity exception in SB 1004, for purposes of this motion, the only reasonable inference is that the patient plaintiffs would have been denied abortion care under the current version of the statute. As for the physician plaintiff's vagueness claim, this court held that the physician plaintiffs had adequately alleged that Tennessee's abortion ban is not clearly defined and is susceptible to different interpretations of what is actually prescribed. That's at page 27 of this court's ruling. That ruling relied upon the denials of care to patient plaintiffs, as well as the physician plaintiffs' allegations that they had stopped providing abortion care to patients for fear of prosecution. Again, second amended complaint makes the identical factual allegations as the first amended complaint on these issues. And again, for purposes of this motion, the only reasonable inference is that the medical necessity exception continues to chill abortion care necessary to preserve the life of the pregnant patient. And that should be clear from the way I've stated this and from our brief, we are not relying on the patient or physician declarations for this purpose. As for the equal protection claim, this court held that the first amended complaint adequately alleged an equal protection claim because patient plaintiffs had adequately alleged that they were similarly situated to non-pregnant persons seeking emergency care, and that their access to emergency care is restricted in a manner not applicable to non-pregnant persons seeking emergency care. That's at page 23 of this court's opinion. And again, the second amended complaint makes the same factual allegations as the first amended complaint, and defendants do not even try to argue that SB 1004 has any impact on whether plaintiffs' equal protection allegations state a claim. Defendants' remaining arguments are mostly repackaged versions of arguments that they made and that this court either explicitly or implicitly rejected on the first Rule 12 motion. I'm going to focus mostly on the vagueness claim before briefly addressing the right to life claim, the emergency care equal protection claim, and then the one claim that was not addressed in this court's previous opinion, the mental health equal protection claim. On vagueness, other than their mootness argument, defendants attack the vagueness claim on two grounds. First, they assert that as a matter of law, the statute is not vague. And second, they argue that there cannot be a pre-enforcement as applied challenge to a vagueness claim. Turning to the first argument, defendants submit a long list of statutes that they claim are comparable to the medical necessity exception in Tennessee's abortion ban. Significantly, they do not cite any judicial opinion that upheld one of these statutes against a vagueness challenge. That by itself should dispense with any argument that this court should decide that the medical necessity exception to Tennessee's abortion ban is not vague as a matter of law. Apart from that, all of these statutes that defendants point the court to are distinguishable from Tennessee's criminal abortion ban in one or more respects. For one thing, many of these statutes do not inhibit the provision of life-preserving medical care. Several are not criminal statutes at all, and one, the reckless endangerment statute, is only a misdemeanor. The medical necessity exception in other states' abortion statutes do not use the reasonable medical judgment standard that 3915-213 uses, but allow physicians to exercise their good faith, their best medical judgment, or their professional judgment. These are all meaningful distinctions because the level of scrutiny that courts apply to vague statutes depends on the nature of the enactment. Here, the fact that Tennessee's criminal abortion ban potentially subjects physicians to up to 15 years in prison and to loss of their medical license, even when they use their good faith medical judgment to provide constitutionally protected, life-preserving care, requires the very highest level of judicial scrutiny. The physician plaintiff's vagueness claim cannot be dismissed as a matter of law. Defendants also contend that the physician plaintiffs cannot pursue an as-applied challenge in the absence of an enforcement action against them. In our brief, we cite the many federal cases that have allowed physicians to bring pre-enforcement challenges to criminal abortion statutes that restrict their practices. And we've also cited the Tennessee cases that permit pre-enforcement vagueness challenges in other contexts. Defendants' argument appears to show that they think that an as-applied vagueness challenge can only be brought in a specific factual circumstance, meaning that a physician would have to present the court with a specific patient who is in the throes of an obstetrical emergency before relief could be granted. That's obviously an impractical rule, and that's not what the law requires. The physician plaintiff's claims are as applied to their practices, even if they are not seeking relief with respect to any specifically identified patient that they are treating at the moment. As alleged in the second amended complaint, the physician plaintiffs are general practice obstetricians. As alleged in the complaint, in the second amended complaint, they have personally treated pregnant patients with a wide variety of obstetrical and other health complications that develop during pregnancy, including, as Mr. Cabot just noted, psychiatric conditions. Their claims are not hypothetical because, as alleged in the second amended complaint, they have already refrained from providing abortion care to pregnant patients with life or health-threatening conditions because they fear prosecution. What the physician plaintiffs need is relief that will allow them to provide care for the range of conditions that their patients will present to them. It's not limited to the circumstances that may have been presented to the physician plaintiffs in the past. That is an as-applied claim as to them and to their actual practice of medicine. As the panel might surmise from what I just said, we respectfully disagree with the court's previous ruling that any portion of the physician plaintiff's claim presents a facial challenge to the ambiguity of the criminal abortion statute. But more importantly, even if some portion of the physician plaintiff's vagueness claim were a facial challenge, as defendants contend, it should not have been dismissed on the ground that plaintiffs do not assert that the medical necessity of exception to the criminal abortion ban is vague in all circumstances. This no set of circumstances test simply does not apply to this case because the criminal abortion statute implicates constitutionally protected activity, the physician plaintiff's performance of life-preserving care. When this court held, in its previous decision, that physician plaintiffs could not bring a facial challenge to the criminal abortion ban, it cited the State v. Crank case of the Tennessee Supreme Court. But in State v. Crank, the Tennessee Supreme Court held that while it is typically preferable for courts to address constitutional challenges on an as-applied basis, thereby limiting the analysis to the facts of the case at hand, when fundamental constitutional rights are at stake, as they are here, a court, I'm quoting here, a court is not required to limit its analysis of a vagueness challenge to the particular facts presented. That ends the quote. In Crank, the fundamental right involved was the right to free exercise of religion. But the right to life at issue here for the patient plaintiffs and the physician plaintiffs' patients is also a fundamental constitutional right, and it is at stake here. So therefore, the same rule that was applied in the Crank case should be applied here, and no set of circumstances test should not be applied to the physician plaintiff's vagueness challenge, even if it is a facial challenge. In fact, the Crank decision followed a long line of decisions where the Tennessee Supreme Court has not required a facial vagueness challenge to allege that a law was unconstitutional in all of its applications, where, just as here, the law is alleged to infringe constitutionally protected activity. Crank, for example, cited Davis Kidd Booksellers versus McWhirter, and that citation appears in this court's opinion. And Davis Kidd did not apply the no set of circumstances test in striking down on vagueness grounds a municipal ordinance that subjected booksellers to criminal penalties for displaying books that described excess violence. The court found that ordinance unduly vague on its face without considering its application to any specific book or display, without considering even whether the bookstore displayed any books with excess violence. Similarly, in City of Knoxville versus Entertainment Resources, the Tennessee Supreme Court held that where First Amendment rights were at stake, the court could consider a facial challenge to an allegedly vague statute, regardless of whether or not the law was vague as applied to that particular defendant. In that case, the court struck down an ordinance that regulated the location of businesses that had a substantial or significant portion of its stock and trade selling books or videotapes depicting specified sexual activities. It struck down this ordinance as unconstitutionally vague, even though it was not vague as to the plaintiff in that case, because that plaintiff's store was clearly within the purview of the ordinance. In other words, the ordinance was not unconstitutionally vague as to it. But because the ordinance chilled constitutionally protected rights, this court struck it down, not this court, the Tennessee Supreme Court struck it down as facially invalid. And I'll just close this out by noting, in contrast, when the Tennessee Supreme Court does apply the no circumstances standard to a facial vagueness challenge, it expressly notes that constitutional rights are not at stake. For example, Tennessee Supreme Court did that in State versus Burkhart. That's 58 Southwest 3rd, 694, which dealt with the ambiguity of a statute regulating gambling machines. There was no assertion in that case that there was a constitutional right to offer gambling machines to customers. Respectfully, we submit that to the extent the court considers any part of the physician plaintiff's vagueness claim to be a facial challenge, that physician plaintiffs be permitted to pursue it through discovery and trial on the merits. I'll stop there and ask if the court has any questions on the vagueness issue.
I do not. Judge Donaghy,
No, thank you.
Chancellor Colbreth.
None from me.
Thank you. All right, you may proceed.
Thank you, Your Honor. Turning to right to life, your defendants' arguments are essentially a reprise of their arguments on the first motion to dismiss. They argue that the abortion statute adequately protects patients' right to life and that the scope of the right to life does not encompass medical conditions that pose minor risks to pregnant patients. But as this court said when it denied defendants' previous motion to dismiss this claim, the merits of those arguments are beyond the scope of what a court is supposed to determine on a motion to dismiss for failure to state a claim for relief. This court held that each plaintiff patient alleges that her medical situation should have been covered, but was not. And that is enough to state a claim. Turning to equal protection, defendants urge two reasons for essentially revisiting this court's previous decision. It should be denied for two reasons. One, there is plainly a factual dispute about whether pregnant patients are being denied medically necessary abortion care, just as there is on the patient's right to life and the physician's due process claim. Second, defendants cannot rely on cases like Sundquist, which this court already distinguished in its previous decision, that state that pregnant women in general are not similarly situated to non-pregnant women because of the potential for another life. This case deals only with pregnant women who need abortion care to preserve their lives and health, which is a subset of all pregnant women. Their claim is that they were similarly situated to other patients who are not pregnant, but do need medical care to preserve their lives and health. The two categories are similarly situated because for each of the patient plaintiffs, in this case, their fetus had no prospect of sustained life. This is not, as defendants assert, a moral position, but rather it's a definitional classification. At the heart of any equal protection analysis is the definition of the comparator groups, and that is how the second amended complaint defines them, which is exactly how the first amended complaint defined them, and as this court already held was sufficient. Turning finally to the one new claim, the mental health equal protection claim, a similar analysis to the one that this court conducted in the first motion to dismiss with respect to the emergency care equal protection claim applies here. In fact, it's a stronger claim because the criminal abortion statute expressly precludes abortion care for pregnant patients with mental health conditions that threaten their lives. Here, there really can be no question that that pregnant patients with mental health conditions that threaten their lives are similarly situated to pregnant patients with physical conditions that threaten their lives. As Mr. Cabot pointed out, the physician plaintiffs do have standing to assert these claims because at paragraphs 170 and 176, they allege that they treat patients with psychiatric conditions. Further, paragraph 216 of the second amended complaint alleges postpartum psychosis as a specific medical condition that could necessitate abortion treatment. And to put it all into context, paragraph 225 of the second amended complaint alleges that mental health conditions are the leading cause of maternal mortality in Tennessee, according to statistics published by the Tennessee Department of Health for 2020 through 2022. Defendants assert that abortion is never the standard of care for a pregnant patient with a mental health condition. And in this argument today, they also said that the distinction drawn in the statute is a reasonable one because mental health conditions are in their description, inherently less susceptible to objective verification than physical health conditions. But both of these arguments are questions of fact that cannot be resolved on a motion to dismiss. The mental health equal protection cause of action states a claim. If the panel has no further questions, plaintiffs urge the court to deny defendant's motion for judgment on the pleadings in its entirety.
Thank you. Any questions, Judge Donaghy?
Thank you.
All right, any questions, Chancellor Colbreth?
None from me.
Thank you. All right, we will return to the defendant's rebuttal argument. Does anyone need a break before we continue? The court reporter needs a break. So we will stand in recess for, can we make it in 5 minutes? All right, please come back at 5 till 11. It's 10 till right now. Thank you. We stand in recess.
Is everybody ready?
Yes, Mr. Williamson.
Jamie, are you there? Are you ready? All right, everybody, I will be bringing back the judges.
All right, I believe we have everyone back. Are we ready to proceed?
I'm waiting on Chancery. Okay, there she go. Perfect.
Oh, there she is. There's Judge Donaghy. All right. We didn't want to start without you. All right. I think we're ready now to hear from defendant's counsel on rebuttal. You may proceed.
Thank you, Your Honor. I'm going to try to go through this as quickly as possible, even though the court generously gave me the full remainder of my time.
Please take your time.
So I'm going to begin with the justiciability issues again. And I think this is where the heart of our dispute is right now. I would start by pointing out that my friend on the other side repeatedly referenced the declarations. And so I think that just goes to show that if the court decides that it cannot consider the declarations for purposes of deciding the jurisdictional arguments as we argue, then plaintiffs have not shown that this court continues to have jurisdiction. And I think it's also important to remember that for the argument that the vagueness challenge is moot, we're talking about an as-applied challenge. And we no longer, even considering the declarations, have a plaintiff who has alleged they were denied an abortion under the 2025 version of the statute. And that's just fatal for any sort of continuing injury showing, which plaintiffs admit is the inquiry, or at least part of the inquiry for mootness. And plaintiffs make clear that their only argument with respect to Shaw, which is the governing law here, is that the amendment is an insignificant one. And they pulled back a little bit from that argument today, but even if we're in the gray area, the declarations don't help them again, because they do not allege an abortion denied under the 2025 version of the statute. Plaintiffs also say that the change is insignificant because they challenged the medical necessity exception, and that provision hasn't changed. But Your Honors, the complaint at paragraphs 237 to 39 repeatedly references the lack of any sort of definitional provision. And we also know, and Your Honors know well, that plaintiffs, the heart of the previous motion to dismiss briefing was plaintiff's allegation that there were conditions that the medical exception conditions in which case the medical exception ought to allow a physician to provide an abortion and wasn't. And the amendment both fills in a definitional provision and adds a list of conditions that mirrors this court's temporary injunction order. And on Shaw, plaintiffs argue that Shaw would allow this case to proceed because we're in the middle of discovery. I don't think that's a correct reading of Shaw at all. Shaw is very clear that the complaint has to provide sufficient notice of the plaintiff's claims under the changed law, and plaintiff's operative complaint does not provide that notice in this case. So best case, they would get to amend, but again, they've repeatedly waived that option. On sovereign immunity, plaintiffs say that we're just rehearsing old arguments. I'm primarily going to rest on the briefs here, but I would point out that plaintiffs admit that the standing and sovereign immunity analyses line up. And so both analyses are affected by the fact that the complaint no longer has any allegations about the governing statute, and that even if you consider the declarations, there's nothing about an abortion being denied under the current version of the statute. And our forfeiture argument is new, as plaintiffs concede. We pointed to case law requiring plaintiffs to spell out their claim. That's just an established rule of Tennessee pleading. They have relied solely on the Declaratory Judgment Act consistently. A single paragraph alluding to 13121 just does not suffice to plead a cause of action under that provision. And again, Roush cuts against them because that involved a claim expressly pleaded under 13121. And plaintiffs' suggestion that the Declaratory Judgment Act would allow plaintiffs to raise constitutional claims in any case is irrelevant, because the Declaratory Judgment Act doesn't waive sovereign immunity. And that's what's at issue here, whether there's an express waiver of sovereign immunity, which there isn't, not whether plaintiffs have adequately pleaded a claim under the Declaratory Judgment Act. As to Colonial Pipeline, we cite Russell, which is also a case on which plaintiffs rely, to show that the mere authority to enforce is not enough to show a credible threat of enforcement, and that's really what they hang their hat on. Moving on to standing, plaintiffs are wrong that the court shouldn't consider whether they have a continuing injury under that analysis. I think it's quite telling that they are citing a federal precedent for that rule. We are governed by Ditto versus City of Chattanooga, which is a Tennessee Court of Appeals case we cited in our brief, that says a party must have continued standing throughout the pendency of an action to avoid invocation of the mootness doctrine. And that decision explains, I think, really helpfully how the standing and mootness analyses often overlap. So I would direct the court to that case. On the Wilmington Trust, yes, Your Honor.
Ms. Adamson, how would this apply, to an issue with a pregnant woman, given how quickly, we have 9 months basically to work with, and typically speaking, these cases take much longer. So how would you fit that case into a situation with a pregnant person who cannot get into court before giving birth?
Well, Your Honor, respectfully, I think that's a question for plaintiffs. They have suggested that merely by the nature of their challenge, they are not bound by the normal injury in fact rule. And that's just not so. There are other cases, there are other situations that involve, I think Your Honor might be getting at the notion that this injury would be potentially repeated in the future. There are doctrines that govern when a plaintiff raising that sort of injury that is difficult to review can raise it, but they haven't made those sorts of arguments here. They have admitted that they have to show an injury in fact, and the injury in fact analysis makes it quite clear that that means a particularized injury. And for pre-enforcement purposes, that they have to show a credible threat of enforcement. And again, they focus on the general enforcement authority of the parties here, rather than any particularized threat of enforcement, which is what they have to show.
Thank you.
So I was about to move on to the Wilmington Trust-based arguments. This court is bound by the reasoning of Wilmington Trust, regardless of whether the particular claim at issue resembled this one. And the court made it very clear that even though that was a private rights case, that it was interpreting the Open Courts Clause for purposes of every claim coming into Tennessee courts. On the question of whether plaintiffs have standing to assert the mental health condition, the paragraphs that they pointed to say that physician plaintiffs have treated psychiatric conditions in the past, but they don't say that they have treated those conditions with an abortion. And plaintiffs do not, tellingly, point to any allegation that any patient plaintiff has a mental health condition. So, and again, we would argue that even if physician plaintiffs, even if those allegations are sufficient to establish standing, that physician plaintiffs cannot rest on injuries to their own patients under Wilmington Trust. Moving on to the merits, unless your honors have any questions on the justiciability points.
Questions?
Okay. Moving on to the merits, plaintiffs primarily argue that we're just re-raising old arguments. And again, I would note that this is a different statute with a different complaint. And the fact that plaintiffs felt the need to introduce declarations in support of their justiciability arguments illustrates that. And again, they cannot rely on those declarations in support of their merits arguments. So they are left with a complaint that does not allege that any plaintiff had her constitutional rights violated under the governing statute. On the vagueness point, plaintiffs chose to bring a pre-enforcement action. And so that comes with consequences for what they have to plead. I think the fact that my friend on the other side spent so much time arguing about this court's reasoning with respect to facial vagueness in its motion to dismiss order illustrates that they are trying to raise a facial challenge via an as-applied challenge. And this court correctly rejected that facial challenge because they can't meet the proper standard. And again, as to the as-applied situations that were the basis of this court's previous motion to dismiss order, the medical necessity exception now applies expressly in those cases. And to the extent we consider any of their, to the extent the court considers any of plaintiffs' general arguments about specific terms being vague, again, this court, both as a matter of precedent and statutory law, has to give terms their ordinary meaning. The fact that two terms might be subject to different interpretations does not make them ambiguous under Tennessee Supreme Court law. And this court has to construe this statute to, if at all possible, to avoid a constitutional issue. And we would also argue that each term applies to a set of core circumstances a person of ordinary intelligence would understand, and thus is not vague as a matter of law. And then I'll just touch very, very quickly on the right to life and equal protection claims. The plaintiffs seem to be ignoring that this court's previous order rested on plaintiff's allegations that the statute was so vague that in practice, it prevented abortions from being provided. And again, the complaint no longer contains allegations about the governing law's impact either on physicians or on patient plaintiffs. And plaintiffs do not even contend that they would be able to amend the complaint to allege that a patient had been denied an abortion under the governing version of the law. And I would say, Your Honor, as well, that this is a legal question based on the allegations of the complaint and the text of the statute. As to the equal protection claim, Your Honor, I think it's very, very telling that plaintiffs are now trying to narrow the scope of that claim to compare pregnant women whose babies do not have a chance of surviving the pregnancy with non-pregnant patients. That's not the way the claim is framed. And so plaintiffs really are not contesting that ending a life makes an abortion, a woman receiving an abortion, similarly situated to a non-pregnant person receiving any other sort of medical treatment that does not affect any other living being's life. And then for the rational bases arguments, Your Honor, I'll mainly rest on the briefs. I'll just point out that we have cited many cases under Tennessee law saying that the rational basis question may be decided as a question of law, and that the court need only find any conceivable rational basis, that doesn't even require evidence of particular rational bases. But Your Honor, we have presented evidence of the General Assembly's particular justifications in enacting the medical necessity exception, and pointed to reasonable grounds for the medical health exclusion as well. So for Your Honors, if you don't have any more questions, I will end there. And I'll just
go ahead.
I'll just ask the court to dismiss the complaint for lack of jurisdiction, and even if it finds it has jurisdiction, to dismiss the claims on the merits.
Thank you.
Thank you.
Any additional questions? Judge Donaghy?
Not at this time.
And Chancellor Colbreth?
None from me.
All right. That concludes the hearing on the motion for judgment on the pleadings by the defendants. Let me return to the opportunity for the plaintiffs to file a written response to the motion to exclude the declarations. Would 5 business days be adequate for you to be able to submit filing?
Meaning that the response will be due next Wednesday?
Yes.
Yes, that's enough time.
All right. And I think we just need the motion and the response. I don't think that we will benefit from a reply. So we will close the briefing after the plaintiffs file their response and opposition, since it's being heard on a rather expedited basis. Is there anything else that we can address today? As I said at the outset, the court will take the motion for judgment on the pleadings under advisement. We will issue our ruling as soon as we are able to do so. Anything else from the plaintiffs?
Nothing further from the plaintiffs, Your Honor. Thank you very much.
All right, thank you. Anything else from defendants?
Nothing, Your Honor. Thank you very much.
Okay, and Madam Court Reporter, do you have what you need?
Yes, ma'am, I should.
All
I've got
right,
emails for everybody if I have any questions.
all right, very good. Thank you all for being present today and allowing us to move this hearing up, and have a good July 4th holiday weekend. This hearing is adjourned.